Again, my name is Neil Lindbergh. I'm a planner and a lawyer. I worked my first planning job, I can't believe it, was 40 years ago in Norwalk, California. So I've been doing this stuff for a while. And I worked in Norwalk for a while and worked in Provo for 11 years, and then decided to go to law school because the lawyers were having more fun than me. So I went to law school at BYU and then worked for a law firm back in Washington, D.C., actually in suburban Maryland. We had an office in D.C., but I worked in the Montgomery County, Maryland office for 5 years, representing developers, so I got an interesting perspective there, and then came back to Utah and worked for the Provo Council as their attorney for 14 years, and I've been with the Salt Lake Council now for almost 3. So that's a quick overview of my resume. I've been involved in land use. You know, I say I may be only an inch wide, but I'm a mile deep. So I know a lot about a little. Anyway, glad to be here. And as we go along, if you have questions, just pipe up so we can answer questions that are on your mind, and we'll be able to do it in the context of the circumstances that we were talking about rather than waiting to the end. A lot of development these days is so-called discretionary development. You know, when zoning ordinances were first invented in the early 20s, and the Department of Commerce came up with a standard zoning enabling act, it was sort of anticipated that once zoning was established, it really didn't need to change, but that was quickly revisited. People realized there were circumstances that needed to be dealt with individually, and so we started to have board of adjustment kind of items, variances. And variances and so forth gave way to conditional use permits. And gradually, we went from a static system to a more discretionary system, and we have elements of both now. We see form-based zoning as sort of the next iteration of zoning. Most zoning that we have now is so-called Euclidean zoning, named after the famous case, I think it was 1926, Village of Amber versus Euclid, where the U.S. Supreme Court upheld the concept of zoning as a legal method of regulating development. So we are using development agreements more and more. At the end, I'll tell you why I think you need to be cautious with these a little bit, and maybe make some comments as we go. But development agreements are essentially suspenders, while we already have a belt, if you will. We have the ability to enforce our codes as regulators. If someone violates the code, we can sue them and refuse to issue permits and do other things that are authorized under the Land Use Act, LUDMA or CLUDMA in the county version. But development agreements make the parties to the agreement personally responsible or liable to perform under the terms of the agreement. And so sometimes we use them in addition to our zoning regulatory authority, and sometimes we use them as an incentive, but there are only certain times when we can do that, and I'll try to explain that. So what are the purposes of development agreements? And I'll just run through several slides here to just kind of articulate the main ones. There may be others. I think the fundamental purpose is to memorialize understandings and assure that a project is completed as envisioned. Because zoning is, shall we say, not a fine-grained tool, sometimes communities want a particular project to occur, and they get frustrated when it doesn't occur. Let me give you an example. This is a real case, happened down in Provo. A developer came in and said he wanted to do a certain project. Everybody loved the project, and the property was rezoned to allow that project. Not too much later, the developer flipped the property. It was sold to somebody else who had a different idea, didn't want to do that project. And so that particular person looked at the zoning code and found something that he wanted to do. It was permitted, and he was authorized to go do it without any need to get a rezone. He just got his regular administrative permits and proceeded, much to the chagrin of the neighbors who had expected a particular kind of project designed in a particular kind of way. There was no ability of the government to do anything different because it was already zoned, and the discretion that the city might have had previously was now gone. We need to think of development agreements differently from other kinds of agreements. We have bond agreements, and we have performance agreements. And this is a development agreement is a type of performance agreement. When I say a performance agreement, I mean if someone's putting in a subdivision, and one of the requirements is that they build roads, we have a contract to make sure that in fact they build those roads. But essentially it is an enforcement means to require legal enforcement of something they're already required to do by ordinance. Again, a belt and suspenders type of approach. Annexation agreement is another type of agreement. So a lot of these are overlapping, but it's good to try to think, as you do one of these, why are we doing this particular agreement? A lot of people will, unfortunately, from my perspective, recycle agreements. I've seen private parties who don't really want to use a lawyer, take an existing agreement and white out the names, fill in their own names, and go for it. And well, that works as long as you don't have a controversy. But when you do, you might find something in there that doesn't work. And the same goes for the government side. Be sure you know what your document says and don't just mindlessly reuse a particular form. Another purpose of a development agreement is to provide a way for a developer to get reimbursed for front-ending infrastructure that doesn't exist. Many times developers will come in and say, I want to do this project here. I mean, and a common way for developers to proceed is to buy cheap property and put in the infrastructure and then sell it. And obviously the margins are a little higher if they're buying undeveloped property and put in improvements as opposed to paying a higher price for something that's already close in perhaps and already zoned. You can say to the applicant, well, this doesn't have any infrastructure, we're not going to approve your permit. That's probably an overgeneralization, but there are ways in which you can say that. I don't think that the law requires the government to spend money to provide improvements, even though it may be zoned for development. If the improvements aren't there, then you're not necessarily obligated to say yes, but you're also obligated to move forward in a reasonable way to provide those improvements under some kind of a plan. Sometimes a developer will say, if I provide an extension on the water and the sewer from point A to point B, maybe it's 1,000 feet down the road from where the sewer ends, will you provide a way for me to recover my costs to the extent that I wouldn't have had to spend them, but when I sell houses in the future? So you'll say, well, yes, we'll do a reimbursement agreement. It's another variation of a development agreement. You say if within, let's say, 10 years, someone hooks onto that sewer line and you've sized it at 36 inches, we only need 10 or 12 for your development. And so let's say there's a 24-inch additional capacity in that pipe. Is the developer going to want to provide that pipe if he's not going to get reimbursed? Probably not. So this is a way to incentivize the developer when they have money available, and these days that seems to be a questionable proposition. But when money was a little looser, they could get financing and provide it. The government didn't have to come up with the money, so it was a way for the government to get infrastructure extended at the developer's expense, with them having the opportunity for reimbursement. Many times those reimbursement agreements will simply say, we'll reimburse you to the extent that people hook on at the rate of X dollars per unit. No guarantee that the developer will get all his money back, so he takes somewhat of a risk. Other ones will say, we're going to give you all your money back in X amount of time. So that's a term which you can negotiate. Another purpose of a development agreement is to give the developer a vested right to proceed and get a guarantee that they know that the number of units or whatever else is in the agreement is guaranteed, that the government can't take it away from them. Now, that doesn't apply very much in Utah, but that concept is still there. Mainly this comes out of California line of cases. This is the Avco Builders case. Most states in the country have what's called a late vesting rule, meaning the rights do not vest until very late in the development process. What had happened until you actually push dirt, begin to pour concrete. What had happened in the Applegate Builders case is they had spent a lot of upfront money, as I recall, principally moving dirt. And this is a huge development. And the government changed its mind and rezoned it to something different than what they'd anticipated, and essentially thwarted the developer's ability to move forward with the project that they had anticipated. As a result, California adopted the Development Agreement statute. Several other cases have followed suit and said you can use the development agreement to vest your rights earlier than they normally would. In California, that's very important and very valuable to the developers. In Utah, we have an early vesting rule. Rights vest once an applicant makes a complete, underline that word complete, a complete application based on whatever the code requires. They are then authorized to go forward and complete the process necessary to get their permits under that application. There's an important point, I'll just do a footnote here about vested rights. I hope all of your ordinances are really clear. We'll talk more about this tomorrow in my session, but really clear about what applications you have in your code and what it is that they get, that the developer gets, if that application is approved. For instance, if it's a building permit application, you get a permit to construct a house. If it's a rezone, that doesn't necessarily guarantee that the subdivision is going to be approved. A rezone simply allows you to apply for a subdivision that's consistent with the zoning. If you apply for a preliminary plat and the plat's approved, what are you vested in? You're vested in a right to apply for final. But if you get a final plat, what are you vested in? You then have the right to go forward and record that plat and create individual parcels of property. Does that guarantee the issuance of a building permit? It comes a lot closer, and probably once the applicant meets the requirements of the building code, then they get a building permit. So you can see that the vested rights concept can be subdivided into separate subparts. If someone comes in and gets a rezoning, they don't necessarily have a vested right to a conditional use permit and a building permit. So your development agreements, if they're going to give vested rights, should be specific about what it is they're getting in return for the agreement. Another thing that we use agreements for is to specify what happens in terms of a default. Most of the agreements that I've seen are pretty weak on this point because everybody's happy. We are in the honeymoon period. We want your project. You want our approval. We love each other. Nothing will ever go bad. Well, we know that things go bad, and especially when the economy gets tough like it has. We need to think very carefully about what constitutes a default, what happens in the case of a default, who has what rights, and we'll talk a little bit more about that as we go on. Developers have been seen abandoning projects right and left. It's cheaper for them to walk away than it is to keep their obligations, especially when they can't sell, they lose their financing, they'll just walk. And then where are you, and what obligations do you have, and can you make that agreement go away, or is it there on the ground? Think about that. We'll talk more about that in a few minutes also. Here's some things to think about as you do your agreements. One, you need authority. You need to know what the public purpose is underlying the agreement. You need to distinguish between what's in your ordinance and what's mere policy. I'm just listing these and we're going to talk about them. What level of discretion applies to the approval? Is it a by right approval? Is it a flexible approval? Is it completely a discretionary approval, like a rezone? What are the scope of the conditions that you can impose on the property, and what are the legal limits? What about potential takings claims, meaning taking a property without just compensation under the Constitution? What about some negotiating details? I'll talk a little bit about provisions to include in every agreement, and the very important one, what about your capacity to manage and keep track of these agreements once you have them? Yes?
Sorry, taking questions during your presentation.
Sure.
Talking about potential taking claims through development agreements. Do you want to spell that out?
I will come to that in a minute, and if I don't answer your question, ask. I've got more slides on that. I just wanted to kind of list the issues here that we're going to step through. So your authority to enter into an agreement. That's very straightforward. It used to be that we had to rely on the Hutchinson case, which reversed Dillon's rule in Utah. Dillon's rule essentially said that local governments only have the power to do what the statutes explicitly authorize them to do and nothing more. Now, under the Hutchinson case, which came out in 1980, the rule is the governments may adopt any police power regulation that is in the public interest as long as there's no rule against it. There's no constitutional rule, no statutory rule against it. That's a very broad grant of authority. We used to invoke that authority as a basis for doing development agreements, transferable development rights, and some other things. Now, both of those things are in the statute. LUDMA explicitly says that one of the purposes of LUDMA and one of the authorizations of LUDMA is the ability to enter into development agreements. It also includes now the statute ability to do transferable development rights. No problem there. The agreement must advance a public purpose. Most of the time, 98% of the time, I'd say we aren't going to have a problem there. But occasionally you will read about agreements where something screwy seems to be going on and we're using the agreement for something that we'd say, what? Why is the government involved in that sort of activity? If we're using an agreement to memorialize the understandings associated with a project, that's clearly a bona fide public purpose, which would be, I think, sufficient to underlie or support legally the agreement. How far can we go in the agreement, and whether we still have a public purpose? I'll come back to that in a few minutes. Okay, distinguishing between policy and ordinance requirements. Tomorrow, I don't know if you've gotten your materials for tomorrow yet or not. I don't know, Johnny, have you handed those out?
No.
Okay. Well, this is 1727A 508 of the Utah Code. This is a provision in FLUDMA. And the first phrase is the applicant's entitlement to land use approval. I gave you a copy of this in the materials for tomorrow. I didn't put it in the materials for today because I thought it would be a duplicate. But basically what this particular section of the code says, among other things, is if an applicant meets the code requirements associated with a particular application, guess what? They're entitled to approval. Can you impose additional conditions that are not in the code? No, not really. Now, if it's a conditional use permit and the code requirements are written in a broad, generalized way, and you make sufficient findings, you may be able to impose requirements necessary to mitigate the harm associated with the conditional use. But I think, as Craig alluded to, conditional use is a presumptively approvable application. And you must approve a conditional use permit if there's some set of conditions that will ameliorate the harm or mitigate the harm associated with that particular conditional use at that specific location. So you can't impose a requirement for an additional sewer line upsizing as a conditional of approval unless you can tie it back to a specific condition in your or development standard in your code, and it's necessary to mitigate harm associated with this conditional use permit at that specific location. That would require a lot of fact finding. We'll talk about how to make fact finding tomorrow again in that session. When a discretionary application is in front of you, then the world is reversed. There's no requirement that the government approve a rezone. It's completely discretionary. There's no requirement that the government annex property. It's completely discretionary. It's a legislative act. The legislative body has the ability to say, yes, it's in the public interest, we're going to adopt this rezoning, we're going to annex this property, or it's not. This is where development agreements generally come into play. You can say to the applicant, you know, we've got a problem with sewer in this area. We want development out here. Our general plan calls for development out here, but we haven't yet had the financial capacity to extend our sewer. So if you're willing to extend the sewer and upsize it, we're willing to enter into an agreement with you and sign the agreement and give you the zoning. Okay, under discretionary scenario, you can do that. In the case of a building permit, probably not. I happened to go to the National Planning Conference in Chicago last week and went to a session on development agreements. And this rule is not the same in all states. I was surprised to hear a couple of well-known commentators essentially saying you can exact all kinds of things, you can require all kinds of things and beyond what the code clearly states as a condition of approval in administrative matters. And I went up to one of the presenters afterwards and I said, well, wait a minute, what about this legislative administrative dichotomy? How can you require more in an administrative context? And honestly, I didn't get a satisfactory answer. I don't know how they're doing it. As their lawyer, I'd be worried. I know in Utah, I wouldn't recommend that we do that because we have this section of the code that I mentioned to you, 1727A508. It's very explicit. If a developer applicant meets the code requirements, we're obligated to give the permit. But in a rezoning situation, a very different situation. Another thing to consider is who's going to be signing this agreement. Are you going to sign it by ordinance, that is adopted by ordinance, or is it making it a legislative act, presumably, because it's being done by ordinance. Ordinances are adopted as an expression of the legislature's policy-making powers. Or are you simply going to have the legislative body authorize the mayor to execute the agreement? I recommend the latter, because if that means it's an administrative decision, it's an administrative procedure. All the legislative body is saying is, yes, we will agree to do this, and we're authorizing our administrative people to execute that with you under these terms. I'll talk more about that too in a minute, about so-called illegal contract zoning. That raises that question. Got a couple slides in here on that. So I think I maybe mentioned the things that are on this slide about the level of discretion, whether it's by right or flexible, whether we're dealing with policy or ordinance. I've heard many developers complain that they're being asked to do things that are a good policy but can't be found in the ordinance. I heard one case where someone went to a conference and decided that the sewer pipe needed to be wrapped in some particular kind of way. It was a new technique, to prevent water infiltration, I presume. And this developer was being asked to do this on the sewer pipe. But there was nothing in the specifications that the city had adopted that says that the government could require it. It's sort of like the Brown case that Craig talked about. Could the city, Sandy City and Brown, prohibit overnight rentals? They could, but they hadn't adopted an ordinance to do that. They did it later. So you can't ask for things in advance. You've got to anticipate the problem that you may have and then adopt an ordinance to deal with it. I like to say in tort law, tort law, personal injury law, there's an old saying, every dog gets one free bite. You don't know he's a bad dog until he bites somebody. It's the same thing with planning and land use. We don't know about a problem until it shows up. But when it does show up, then we're obligated to adopt an ordinance to deal with the problem. That may mean that in some cases, a bad dog gets a free bite. We have a problem we have to put up with in one case until we write an ordinance to deal with it in the future. Okay, takings claims. I I assume some of you have heard about the Nolan-Dolan rule, but for those of you who may not have, I'll just review it very quickly. These are two U.S. Supreme Court cases that established two basic rules with regard to taking the property by the government. The government can take property for a public purpose as long as they pay just compensation. But when that happens, when we have an exaction that's imposed on the private property owner, we have to meet two requirements. There needs to be nexus and proportionality. Nexus means that there's a connection between the exaction and what's going on the property. We can't exact something for a new school a mile away if it has nothing to do with what's going on the property. But if we have the need for a road improvement immediately abutting the property, that happens a lot. Developers will be required to dedicate additional right-of-way to meet the master street plan width as a condition of development. Let's say, for example, a developer is doing a project with 10 lots, and there's a 2-lane road out in front of the property. The master plan calls for a 4-lane road, and 100 feet that way, and 500 feet that way, there is a 4-lane road. And we need a 4-lane road to complete that segment. So we say to the applicants, well, we'll be happy to approve your subdivision, and we'll put it into our development agreement. As long as you give us a 4-lane road, we'll approve it. Is that okay? Well, let's look at it. There's nexus, because the need for the road abuts the subdivision, but is there proportionality? Does access to 10 lots require a 4-lane road? Obviously not. A 2-lane road would suffice. So it fails the proportionality requirement. So if that person came to you and in an administrative context, meaning the property was zoned for that subdivision, and the individual merely needs to go through the administrative process to get the approval, can you ask for the additional 2 lanes? No, you'd have to pay for that. If it wasn't zoned, and he says, I want to rezone the property for this subdivision, and let's say it's zoned on either side for development. In that case, you can exercise your discretionary authority to some extent and say, well, we'll rezone it if you're willing to provide the improvements on the street, and we'll reimburse you. That's the negotiating point, but we won't reimburse you. The facts of the case, though, will make a big difference. If that subdivision I'm talking about is out in the hinterlands, and there's a lot of undeveloped property, your case is probably stronger than if you have a 1-acre parcel in the middle of R1 developed property all around. The court might say if you refuse to rezone in those cases and are trying to exact something, that might go too far. I don't know that it would or wouldn't, but I'd be a lot more careful if the zoning all around my parcel is already zoned and I'm asking for the world as a condition of rezoning. Although theoretically, the government doesn't have to approve a rezone. So, again, the facts of the case would have to be reviewed with your lawyer to make sure that you were on good ground. But as a general rule, in a rezoning case, exactions can be discussed. Ad hoc exactions, I've explained, they can't really be imposed on an administrative approval. Already zoned, meet the standards, you're good to go. Okay. Sometimes I think people have believed they can use a development agreement to basically abrogate what it says in their code. And they write something different in the agreement. It's plainly different than what their code requires. Here's my view. If your code says you can do this much, you can tighten it down with the agreement and restrict it. But if your code says you can do this much, can your development agreement authorize you to go beyond the boundaries of the code? Can't go that direction. So you can shrink down, if you will, or reduce the scope of the applicability of the code, but you can't go beyond it with a development agreement. You can't use an agreement basically to override your code requirements. But you can use an agreement to restrict your code requirements. And the most common example would be if you have a list of 20 permitted uses, and this particular applicant wants to do one use, You say, fine, we'll do an agreement with you for that one use, and the others you agree not to use, you're not gonna use those, and all of your successors won't ask for those. We're just gonna give you this one. That works. Sometimes when we go too far and a project has begun and the developer's taken advantage of this approval and begun as a problem, his project, and then something happens and he complains, sometimes the court will say, well, you, Mr. Developer, got the benefit of that agreement, so we're not going to hear you complaining right now because you already got a financial benefit. That is, I think, a less than likely case, but it's possible. I've seen cases that say that. It's not a winning argument necessarily, and I wouldn't put a lot of weight on that particular argument. What if a developer comes in and he wants to provide more landscaping, more gingerbread on the building, higher quality building, higher quality materials, make it a green building, and he's ready to do all these things. So what usually happens is when a developer needs a rezoning, and I'm speaking in a rezoning context, is you'll get a dog and pony show at the council, at the planning commission, and all these wonderful things that they're going to do. And it's really going to be great. You know, the most wonderful things in sliced bread. What you do at that point, in my mind, is you say, fine, are you willing to impose those conditions on yourself in an agreement? Now, this is the proposal you're making. You like your proposal. Are you willing to put those in an agreement so they'll be on paper and we can all rely on it? Yes, I'm willing to do that. Okay, there's your opportunity. Write them down. He'll go beyond, he's willing to go beyond what the code requires. And he's going to put twice as many trees in. Much better building material. He's going to make it brick instead of siding, or whatever the case may be. Now, let's talk about so-called illegal contract zoning, which is probably one of the main questions that always comes up with development agreements. What is illegal contract zoning? And how do you approve a development agreement and avoid illegal contract zoning? The basic rule is this: the government cannot bargain away the police power. Okay, the police power, what is it? The police power is the ability to regulate in the public interest, for the benefit of the public. The council always needs the ability to make a decision legislatively, whatever it is. You cannot bind the hands of the council to a future act. So that's where we get in trouble sometimes with the way development agreements are written and processed procedurally. Let me give you a couple of examples. So let's say the developer comes in, this is a rezoning context, I'm talking about legislative context, and he says, I'm willing to provide these improvements if you're willing to rezone it. And so the parties enter into a development agreement that essentially says, yep, we're going to do that. And the council votes and says, well, we agree the development agreement is fine, and we agree that we'll rezone it 2 months from now. Is that a problem? That's a problem, because it's a future act of the council. And the council might change its mind, and it always needs the ability to say yes or say no, depending on whatever it is they want to say. Now contrast that with this scenario. Okay, same facts. Except you say, okay, Mr. Developer, you're willing to enter into an agreement? Great, let's negotiate an agreement, okay? Now, Mr. Developer, I'd like you to sign the agreement and offer it to us, and we'll decide whether we want to accept it. Call that a proffer. He proffers a development agreement. He unilaterally offers the government an agreement. We've already negotiated it, and he signed it. At that point, the council is free to accept it or reject it. If they accept it, they say, fine, we accept it. We authorize the mayor to execute it, and in the same night, we'll rezone the property. Or we'll rezone the property subject to the execution of the development agreement. Meaning we won't finish the paperwork on the rezone, we won't sign the ordinance of the rezone, we won't publish the notice of the rezone until that agreement is signed by the mayor. You see the difference? It's a very important procedural difference. One, the first one is, I think, illegal contract zoning, because you're asking the council to do something in the future, yet you vote, and so you've tied the hands of the council, versus the other one where the agreement is in place. Then it's rezoned. So put all your dominoes up front, yes.
In that case though, Neil, you haven't done due process. You're agreeing to rezone without having gone through the hearing process, notifying surrounding properties?
No, that's a great question. I am not trying to say we aren't going to do that. We're following.
No, you're gonna do that, but you're gonna do it subsequent. You've already made the decision to rezone without having gone through that process.
Okay, good question. Let me clarify. So the developer comes to he makes an application for rezoning. Okay? He goes to the planning commission. He proffers, and he says, I'm going to do all these wonderful things. Then it comes up to the council or the county commission. We have a positive recommendation from the planning commission to rezone the property because we're going to do these wonderful things. And then at the legislative level is where we enter into the development agreement. So we're in the middle of the rezoning process in the normal way, following the normal procedure. We say, I would always say to the applicant, are you willing to put that in writing? Yes, I'm willing to put it into writing. Okay, we'll write an agreement. We would pause the process till the agreement was written. He'd sign his side. Then we go to the council. We'd finish the last step. We'd have our hearing, and the council would say, yes, we approve, or we don't. If they don't, he didn't have an agreement. He just had a unilateral offer of the agreement. If the council says yes, then the mayor signs the agreement, and we process the zone change ordinance. That's a great clarification. I appreciate you making that. Sometimes people will complain that development agreements take away the police power because they bind the hands of the government to do things in the future. After all, the purpose of the agreement is to grant a vested right. So we have to make sure that the writing of the agreement is such that the government still has the ability to impose generally applicable police power regulations. For instance, let's say there's a rule that says all the fire hydrants need to be upgraded from this size to that size. Well, the developer doesn't have a vested right to certain fire hydrant sizes. He's going to have to comply with that. What he might have a vested right for is a certain number of units and a certain number and a certain design configuration. That's what he gets. But let's say he waits for 2 years before he finally applies for a building permit. And by that time, the building code has changed, and we have new window requirements in the building code, or new insulating requirements in the building. He says he have a vested right, and he can avoid those? No. I would not put that into your agreement. If you intend to allow them to build under the old rule, I guess you can do that, but your hands might be tied. You might create a problem with the new building code versus the old one, because it's coming in 2 years later when there's a new rule in place. And if you leave that door open, then you have not totally surrendered your police power authority. You have simply used a development agreement to bind the city and the developer to a particular design in a particular situation and maybe in a particular phasing. You see the distinction? You can't bargain away, can't give away all the rights and privileges you have as a government. Your development agreement should say somewhere that by executing this agreement, you are promoting the public welfare by executing the agreement. You're making sure that the developer's promises will be fulfilled. That is a current benefit of the agreement. You're not surrendering your police power authority. You're promoting the public welfare under the police power. And then we have a contracts clause argument as well about the impairment of contracts, which is also another reason development agreements have been upheld. If we are in let's change the facts again in my hypothetical. Let's say we're now in an administrative context. There's some problem that you want to solve, and you want to use a development agreement. I'm going to pick another example. Let's say that the sewer, again, isn't big enough. The guy has a right to go forward with his application. You're thinking about limiting the number of units that he can build because the sewer's simply not big enough. Now he says, well, I'm willing to upsize the sewer if you're willing to let me have the number of units that the code would already allow. Let's say it's 10 units per acre, just pick out numbers. But he can only build 2 units per acre because of the limitation on the existing pipe. But he's willing to improve it, even though it's an administrative condition, situation, he's willing to improve the property because that will get him the maximum density allowed under the zoning existing on the property. Okay? You need to make sure that it's truly voluntary. Because one of the issues that will arise is if you impose that, was it imposed or was it voluntary? So you need to be sure that if it's really voluntary, make sure it's voluntary. And the agreement should say it's voluntary. In my agreements, it will always say, you know, we're not making you enter into this agreement. You are willing to enter into, and you're acknowledging that you're doing so voluntarily. If there's a dispute later, that will go a long way to solving that problem. Okay, quickly, we're running out of time. There's a list in the materials that I provided. I hope you have them. There's a checklist of things, provisions that should be in every agreement. I'm just going to run through a few of them. What is it exactly that's being approved? Is there a phasing scheme? What are each party's obligations? Some agreements that I've done say the county will build this, this, and this. The developer will build this and this and this. We have it subdivided by roads, by water, by all the different kinds of infrastructure things that the developer or the government is going to provide. I mentioned about defining vested and the reservation of police powers. State how this project fulfills the general plan, your other planning documents. This is in furtherance of your public policies. Again, state that it's a present exercise of your governmental authority rather than abdicating your police power authority. Define what infrastructure will be provided, when it will be provided, what construction standards do they have to meet. A lot of times the agreements are not in sufficient detail, and so we end up arguing in the future over exactly what was it we agreed to. We need to try to foresee all these details. What if the developer wants to sell something to someone else? You need a provision in there for how would the transfer from developer 1 to developer 2 occur? And did they have to tell you about it? Or can he just sell it to somebody? You know, he came out, his job was to find the property, get it entitled, get it approved, and now he's flipping it to somebody else from California. And the California guy comes in and he says, hey, I never signed that agreement. I never even knew about it. Now, hopefully you were wise enough to put it on the record, and you had a provision in there that says this agreement runs with the land and it applies to all successors and assigns. You can probably make it stick. But you ought to have a procedure for how that happens. I wrote a provision that would say, you got to come in and tell us when you're going to change, and we'll record something on the agreement that says Mr. Black is no longer responsible, it's now Mr. White.
So does that just become an addendum to the agreement?
You can do it as an addendum to the agreement, or you can put language in the agreement that specifies the procedure and then just put your documentation in the file under that procedure. The problem with an addendum to the agreement is you're going to have to go through the same procedure with the council and approving the addendum. That's just more complicated and maybe more political. Perhaps now people feel differently about this project than they did 2 years ago. Another important thing is, what about security guaranteeing performance? I have seen very, very few agreements in my career where the developer fails to perform and the government steps up to take his place. Theoretically, that's what we think we're going to do, is we'll finish it if he doesn't. But most governments don't want to be in the position of being the developer of last resort. They want the developer to finish it. So your security provisions should reflect what you're going to do. In fact, before you enter into the agreement, you should do your due diligence and make sure, number one, that this property doesn't have a bunch of liens on it, that the developer really is the owner of the property, or this entity really is the owner of the property. Sometimes you find strange things when you start looking into the title. So you need to make sure you've got a clear title, And if you need to go against that property, you're in the first position to do that. Provisions can be put in that says, if we're feeling insecure, we, the government, are feeling insecure, we can make you show us your money, or show us what financing you still have available, so that we're good, we feel good about continuing to issue these permits. Because if you get halfway down the road and it fails, maybe you got houses, but you don't have a sewer to those houses, oops, the last leg didn't get constructed, that's a real problem. So you need to make sure your security is there, and maybe it needs to be refreshed periodically. If that's not in the agreement, you're going to have difficulty making it, or solving it later. Who has standing to enforce the agreement? Does the neighbor across the street have standing? I would always put in my agreements, no third-party beneficiary rights. The only people that get to enforce this agreement are the parties to the agreement, not the neighbors. If you put neighbors in there, then you're going to have potentially all kinds of lawsuits against the city asking you to do things that you didn't anticipate. Is the agreement run with the land? Run with the land there is in quotes because it's a term of art in the law, but basically it means, will it continue to be bound to this parcel of land regardless of the change in ownership? I had a case where the developer, this is a very large project, I think there was probably 7,000 or 8,000 units, and it went sideways. It's in southern Utah. And the bank took back some property, and then the bank was trying to argue that they could sell the property free of the agreement. They were not bound any longer. Did a lot of research, and I believe they are not free of the agreement. Because unless the parties agree to release themselves, the original parties or their successors can unwind an agreement. But if one of the parties doesn't want to do that, then it's going to still be there. And it will apply to future property owners as well as those in the past. Yes?
Do you recommend at that point to record the agreement in the
The
county
agreement should be
recorder's office?
recorded immediately after it's signed. Put it on the public record, absolutely. Yep, and there should be a provision in the agreement. I mentioned define clearly what's in default. Are any vested rights remaining? What can the government do if there's a default? Can you decide not to issue any permits? Does land have to be restored? Here's a very important one. I think that if the other side's not willing to do this, you need to really think hard about whether you want to do a development agreement for any sizable project. And that is limit the remedy for the government's default to specific performance. Not money damages, no money damages. We have a really bad case in Tooele, and I gave you a citation there. It's a $20 million verdict that went against the county. It's still not, is it Tooele City or Tooele County?
City.
It is the city? Thank you, Craig, I thought it was the city. The city attorney says we're not done yet. My reading is we're pretty well done, and the city's in a deep, deep hole. Just say, if we, the government, default, the court can make us do what we said we'd do in the agreement. That's specific performance. No money damages. We need to be very careful about how you write that provision. Negotiating an agreement, I'm not going to go over these because we're running out of time. I'll let you read these. The basic thing that I would say is recognize that the agreement has to be good for both sides. If you think that you've got some big lever over the developer and he signs the agreement and you say, aha, got to sign it, probably going to go sideways. It needs to be good for all parties. Anyone that has undue leverage over another, that situation will change, and they may not perform because they thought it was unfair, and they'll backtrack, and then the agreement really won't accomplish what you intended it to do. I mentioned these things at the beginning. What about your ability to track the agreements? I've heard from so many planners that say, gosh, we have these agreements, but we don't know what they are and what they say, and when someone comes in for a permit, we don't know where it is. My answer is, oh gosh, don't we have a computer? Can't keep track of this stuff? I've never understood their complaint. I think it's a simple administrative matter to track them, but apparently it is a problem on the ground. So we need to think about how we do that. Political will to enforce the agreements. Circumstances change. Unless you're willing to step up and sue on the agreement, it's not worth the paper it's written on. It's just a feel good at the front end. You need to, I've seen legal departments who've said, well, we're not gonna win that case. We're not gonna even file a lawsuit. Well, your development agreement is worthless in that case. Need to be careful to avoid unintentional breach. If you've got a whole bunch of these agreements out there, you need to know what they say so that you don't do something that violates the agreement and puts you in a position where you can be sued and you lose because you breached the terms of the agreement. One way to deal with that, if you're doing a lot of these, is use a form agreement. They all say the same thing, hopefully, or pretty close to the same thing. And the way I dealt with that was when the developer would come in, they don't want to spend money on lawyer to do this. And so when we talked to them about doing an agreement, I said, well, we have a form and I'm happy to prepare the agreement. Give it to you, you can review it and let me know what you think. 99 times out of 100, they would say fine, and they would accept the agreement. A couple of times people wanted to completely renegotiate every detail. Okay, we did that in a couple of cases, but if you're renegotiating everything at that early stage, hair in my neck goes up and I'm thinking, ooh, this has got trouble written on it. Better be careful, better be careful. Making sure your security is sufficient. Okay, when things go wrong, a contract is a contract is a contract. This is a contract. Did I make that clear? It's a contract. You're as obligated as they are. I've had clients come to me and say, oh, well, we don't want to do this anymore. We have new politicians. This agreement was signed 5 years ago. We have a completely new council. They don't want to do this anymore. Beware. You'll get in trouble. It's a contract. And contract principles apply. And if your agreement is written to allow it, then damages can apply. This Mammoth Lakes case from California I put in there was a $32 million verdict against the city. I think they settled it, but the terms of the settlement are confidential. I looked this morning to see if I could find anything more, but the city was thinking about doing bankruptcy. There was a case up in Idaho, it was a group home case where it was actually, Boise County, Idaho. They tried to declare bankruptcy to get out of a big judgment on a group home. The bankruptcy court said, nope, not going to let you. You have enough money, or you can raise it. You'll have to pay it. The Brave case in Beaver County, in that case they adopted the development agreement by ordinance, and it had a particular effect that you can read about. Basically the court said, you want to have your cake and eat it too. You want to call it administrative and legislative and get the advantage of both situations. We're not going to let you do that. So these are a few cases. The Tooele County case, I don't know all the details. All I know what's going on there is what I've read, but it's a $20 million verdict. Apparently both sides stopped performing. Both sides claimed that the other side was breaching. The jury verdict went for the developer. What was it, for $20 million, and I think there was $3 million for the city. So the offset was $17 million more or less that the city owed the developer. The original court case, the judge said the jury verdict responses weren't harmonious. There was no way to harmonize all the responses in the jury verdict form, and so the trial court set aside the case and said, we're going to set aside the verdict. But that was overturned on appeal. It's still, apparently, there's a possibility of appeal before the Supreme Court. I think they asked for cert, but I don't know if anyone knows anything more about that case. You'll have to watch it. But the Court of Appeals has ruled on it, and that's the last rule we have at the present time. You know more, Brent, on that case?
I talked to Bruce, there's some detail about it just last week, and in his usual way, he just says that there was nothing wrong with those development agreements. It was just a question of breaching a contract. It's just a plain old contract.
But apparently the development agreement didn't limit money damages.
Yeah.
And so we can use the Tooele case as a real good example for why we need to limit money damages. And if they won't accept specific performance is a sole remedy, then put a number in there and say our damages will not exceed X if we're guilty of something. So, in conclusion, essential elements of using development agreements is make sure you correctly invoke your authority. Realize whether you're in an administrative or legislative circumstance, understand why you're doing the agreement, and make sure you have the ability to manage them and to enforce them. And lastly, I would add, they're not a panacea, they're not a cure-all, it is a tool that you can use. But like any tool, you need to use it carefully, or it can cut you. Thank you very much.